am going to try and find counsel. I don't know if I can afford any. So, yeah, it'll probably be myself then.
Your Honor, for the record, she's receiving $5,800 of spousal payments a month.
Welcome to The Wall. Today we're looking at a divorce case where the man has over $800,000 in investments, and yet his ex-wife, who already receives $5,800 a month in alimony, wants half of everything. House, cars, savings, investments, she's claiming it all. Justice or system abuse? If you enjoy this content, hit the like button and subscribe. We're on our way to 150,000 subscribers, and with your support, we'll crush that goal. Share your experience or opinion on these kinds of cases in the comments. And without further ado, let's get started.
In the matter of the marriage of Kathy Ann Puls and John Albert Puls, case number 2024 DM 349. The petitioner, Kathy, appears apparently representing herself at this point, her previous attorney having withdrawn from this case. Riley Broyles appears as counsel for John in this case, who apparently is appearing in the office of his attorney by Zoom. This matter comes before the court at this time for a pretrial conference. The court does have respondents' pretrial questionnaire. Appreciate that, counsel. Your client's position is clear to the court. Kathy, I don't have a pretrial questionnaire from you.
I didn't know I needed to give one.
All right. Have you had an opportunity to look at the respondent's pretrial questionnaire?
Briefly. I do have issues, though.
Okay. Have you communicated your issues to Ms. Broyles?
We tried when I had an attorney before, but the numbers on like Morgan Stanley and everything else, it keeps changing. So I wanted you here as a witness to everything. I wanted to ask questions of like it's ridiculous. The difference.
And what's ridiculous?
He has listed like the Celica and the Cadillac as assets, and those were gifts. And the original amounts that were on listed, like the Morgan Stanley, for it was originally 820,432 and 11 cents, and now it's 800,758.55. That's almost a difference of $20,000. And the portfolio management, there's a difference of almost 15. And the UMA 4897, there's a difference of almost, well, a little over 7,100.
All right. Can you explain these discrepancies, Ms. Broyles?
Yes, to a degree, Your Honor. So the original amounts that we had listed were from a old spreadsheet, and then we were able from Morgan Stanley, and then we were able to obtain more accurate information from Morgan Stanley with updated statements, and so we updated the spreadsheets accordingly. The first couple spreadsheets, we didn't have all of the information we needed, but since that time, we have received the correct information. And I believe, I have to double check my email, but I believe we provided that information to Ms. Puls' previous attorney way prior to her withdrawal in the case, Your Honor.
Right. Is there consistency in the valuation date on this spreadsheet?
Yes, I believe there, as close as we can get it, Your Honor, there should be.
Okay.
Okay, well, wait a minute.
Oh, hell no!
As we can see in this case, the plaintiff, Mr. Broyles, is seeking to end the spousal support or alimony payments to his ex-wife. This appears to be a high-conflict divorce, where she is doing everything she can to maintain those payments, including presenting gifts as if they were marital assets. Yes, you heard that right. She's trying to count a Celica and a Cadillac, which were personal gifts, as part of the marital property, something that, in many courts, makes no legal sense. It's also clear that this couple has significant resources. Mr. Broyles has over $800,000 in investments with Morgan Stanley, which definitely complicates her claim of need. When one spouse has greater financial resources, the other must demonstrate actual need, not just a financial imbalance, to justify alimony.
The date, let's see, on this spreadsheet, it was January 28th of 25. When was the last time you received information from Morgan Stanley? Let's see.
So the figures that we are using for the Morgan Stanley account are from December 2024 reports.
Yeah, this is from January. These differences are from January.
I'm not sure, Your Honor, I'm not sure what she's looking at, so it's hard for me to say what she's looking at versus what it was included in her pretrial questionnaire. And I mean, frankly, at trial, I'm happy to provide all of the supporting documentation that supports the figures that are on our spreadsheet. So I don't want to box myself into a corner by making statements. I don't have the statements. I wasn't prepared to fully discuss those today. So.
All right.
Oh, and
So you're requesting this court establish a valuation date, essentially of date of filing, which would relate back to September of 2024. Is that correct, Ms. Broyles?
Yes, Your Honor. I will say, kind of a caveat. One of our the Morgan Stanley figures that we're going off of are from a December 2024 report that we have, and that was as close as I believe as close as we could get it to the date of filing.
All right. Is there any problem with that being the valuation date, Kathy?
no, not at all, but the numbers have changed. I mean, even the one that I received today have changed since January.
Right. I'm not surprised that
This-
account values would change even on a monthly basis. Either they're going to go up or down.
Absolutely, but it was ordered by the court for accounts to be frozen at the November 1st court
Has there
date.
been invasion of these accounts?
There has not, Your Honor. I would assume that any changes are as a result of the market changing. These are investment accounts.
All right. That certainly seems logical.
Okay. So also the money that he took out of the checking account when he was issued the restraining order and gave it to Morgan Stanley, that needs to be put back. I was supposed to be issued $75,000 in difference because of what was sent to Morgan Stanley. It was half of what he had sent to Morgan Stanley as an investment. And I never got that back. As well as he wants me to give him the house. And he's talking about his father's Cadillac or Corvette, which I have no issues in just giving him because it's an heirloom. But I also used my inheritance to put a down payment on that house of $60,000. And we bought that house together. So why would I just give it to him?
And I don't know why you're getting into this today.
Well, exactly. I don't.
This isn't a trial. And I just wanted to determine if we have disputes and what issues are in dispute. Really, these discussions might be better held with Ms. Broyles. If you have a complaint with their proposal, they've at least laid out for you what they're going to be proposing to the court. You haven't done that for them.
The lack of a lawyer is causing this woman to sink on her own. She's trying to argue complex financial figures, assets, and account transactions without legal preparation or a clear strategy. But even so, this isn't the trial, and the judge reminds her of that. This stage is only about identifying the issues in dispute, not resolving them. So her complaints, like the alleged $75,000 loss or the $60,000 she claims to have contributed to the house, don't carry any weight at this point. The only thing that matters is clearly outlining the points of disagreement. And honestly, she should have negotiated a settlement when she had the chance, especially knowing her lawyer stepped down. When an attorney drops a case before trial, it's usually because there's not much left to defend.
I
understand.
don't know the law. I don't know what I'm supposed to do. And also
Well, actually, I think you do, because you seem to be able to identify disputes quite readily where your problems are with their proposal. Here would be my suggestion. In fact, it'll be my order. Kathy, if you're going to represent yourself on this thing, then I'm going to establish 14 days from today's date for you to give a formal response to Ms. Broyles on the issues on the pretrial questionnaire.
Okay.
If it could be done in a manner that she could understand, you might even just take a copy of it, write your comments on it. I'm not going to tell you what format to use, but if you've got an issue with what her proposals are, you let her know what those issues are. And
Okay.
why.
And
14 days to do that, because I think Ms. Broyles needs to know what's in dispute and what isn't.
Okay. As well as perjury and
I don't know what you mean by perjury.
on the trial from November 1st.
Okay, there wasn't a trial on November 1st.
Well,
There was a hearing conducted.
he got on the stand and basically just he lied, just outright lied. And it's $4 a page to have it printed out in Butler County, to have the transcript printed. I can't afford that. And he's supposed to pay his alimony on the 1st of every month. Last month, he didn't pay it until the 10th. This month, I still haven't gotten it. He took everything we had. I don't have a job. I'm disabled. I'm upset. And I think,
Are you receiving disability from a government?
no.
Oh, okay.
He stole my identity. Everybody is using my identity.
These are baseless allegations, perjury, identity theft. There's no basis for these allegations. I'm going to object to the line of.
So noted. Again, she's not under oath. It's not testimony. She may have a basis for what she's saying, and she may not. I'm not going to try to sort that out today. Just be careful what you say here, Kathy. I just hope that if you are going to make accusations, you got proof to back it up.
I do.
Okay. That's the kind of thing that we sort out at the trial.
Stop it. Get some help.
Let me make something very clear. I'm not a supporter of alimony. I firmly believe it's abusive to have to keep supporting your ex when you're no longer together, when there's no shared home or mutual responsibilities anymore. That said, what we're seeing here is a woman making multiple accusations without solid evidence. Accusing someone of identity theft and perjury without clear, documented proof can backfire. The judge gave her 14 days to formally respond to her ex-husband's questionnaire, a clear sign that talk alone isn't enough. You need documentation and a well-defined position. Because since the hearing started, she's been listing everything she's claiming, point by point. The $75,000 invested, the $60,000 she says she put into the house, the cars, the alimony. That's not someone who's lost. That's someone who either knows exactly what she's doing or is very well advised legally, even without an active attorney.
At least right now, I don't have a real perception that there's anything that's undisputed. If so, very little. We've got issues regarding property valuation, property division, perhaps spousal support.
Mm-hmm.
Those issues still exist.
The fact of the matter is I just wanted it to be fair and equal. and reasonable. I mean, he wants to just discontinue paying spousal support when I've been the housewife for over 33 years. So, yeah.
Are you capable of rejoining the workforce?
No, because I pretty much gave up my mobility, having children, raising those children. I used to get ablations on my lower back. They give 8 different sections of my lower back. I can't afford that anymore. And I had to quit jobs because of the pain. I do not take pain medicine. I do not drink. So, yeah, there's not much I can do. I've had surgeries. I've had my left knee replaced 3 times, my right once. I've had a I've had 7 different surgeries.
All right, Ms. Broyles, unfortunately, this court does not have May or June trial dates to offer. In fact, I think that the most viable trial date that I can offer at this point would be Tuesday, July 29. Mandy, would you check that to make sure nothing else got scheduled very recently here? Tuesday, July 29.
That would work for me, Your Honor.
Very well. Court will establish Tuesday, July 29, 9:00 a.m. Courtroom B, in person, Butler County Judicial Center in El Dorado, Kansas. I'm going to establish a deadline for providing of an exhibit notebook. Broyles, Kathy, you're going to have to provide to the opposing party your exhibit notebook by 5:00 p.m. on Friday, July the 25th. I would ask, I suppose since we're doing it in person, I don't necessarily need it in advance, but I want the opposing party to have their exhibits provided to the other party by the Friday before.
Okay.
Let me explain Kansas law. The woman claims she was a homemaker for over 33 years, which is a strong legal argument to request spousal support under Kansas law. According to KSA 23 to 2902, the court can grant maintenance considering the length of the marriage, each party's ability to be self-sufficient, and the history of non-financial contributions, such as homemaking and child-rearing. She stated she can't return to work for medical reasons. But remember, in the absence of formal medical evidence, like a certified disability, this claim must be backed by documentation for it to hold up in court. Everything presented, the alimony, the division of assets, all of it will have to be resolved at trial. The court won't make decisions without formally submitted evidence. If she fails to present clear proof that everything she's claimed is true, including the accusations, she could lose the case. But let's take a look at the closing.
That'll give you only one business day to scrutinize what's in it. But I think under the circumstances, that's appropriate. Friday, July 25th by 5:00, exchange of any documentary exhibit that you intend to introduce. I would prefer it to be in an organized notebook form.
Okay.
Broyles, I know you're quite familiar how to do that. I trust Kathy will also do the same.
I'll seek some advice.
Okay. So what it comes down to, Kathy, you're going to need probably to make 3 of them. You're going to need one to provide to Ms. Broyles. You're going to need one for yourself. You're going to need one for the court.
Okay.
That is if there are any documents that you intend to introduce.
Mm-hmm.
And I kind of get the impression that you might.
Mm-hmm.
And it's your decision to represent yourself in this case?
Am going to try and find counsel. I don't know if I can afford any. So, yeah, it'll probably be myself then.
Your Honor, for the record, she's receiving $5,800 of spousal payments a month.
I've also been jumping around from hotel to hotel because I did not want to stay here. And this court case has been drug out for so long that I finally found a place to stay. So as soon as I can save a little bit, then yes, I will most definitely find some counsel.
Okay, it's just that we do need to have an end to this case. I agree with you that
Absolutely.
it's been pending long enough,
Exactly.
and we've established a firm trial date in person on July 29th.
Okay.
And you've got a couple of months here to get your house in order and everything prepared.
Right.
We'll expect both parties to be ready to present evidence to try to work toward finalizing this case on July the 29th.
Absolutely.
Okay. And remember about that 14 days to get your position in writing to Ms. Broyles.
Okay. Which means my position. What do you mean?
On the issues that she's laid out in her pretrial questionnaire, her client's position on, I think, all the issues in the case.
Okay. Okay. I got you. All right.
If
Okay.
that isn't okay with you,
No, that's fine. I
then
will.
you need to make sure she knows exactly what parts of it you're disputing and what your position in return would be.
Okay. Okay.
Because it's only fair because you already know
Oh, yeah.
they need to know your side.
Absolutely.
Okay. Very good. Trial date again, Tuesday, July the 29th, starting at 9:00 a.m., courtroom B, Butler County Judicial Center. All right, Ms. Broyles, anything else that the court needs to address at this time?
I do not believe so, Your Honor. Would you like me to file a pretrial conference order?
Essentially, what would you include in this order since
Just
you
the
don't really
deadline.
have, excuse me?
I apologize for interrupting. Your
Go
Honor.
ahead.
Just the deadlines and the trial date. So that's.
Please do so, counsel. I think that would be helpful for purposes of stating it in the record.
Okay.
So thank you. I appreciate your efforts in that regard. All right, Kathy, anything further we need to address at this time?
The transcript from the trial on November 1st.
Okay, that was a hearing, not a trial, but
Well,
you can order that from the court reporter, but you'd have to make
Okay,
the
that-
appropriate deposit for their preparation.
right. Okay. All right.
Okay.
All right.
Very well then. If there's nothing further then, this matter will currently be in recess, and this meeting may be ended for all.
God damn it! You can't make this shit up!
From the start, this woman claims she can't afford a lawyer, yet she's receiving $5,800 a month in spousal support. And what does she do with that money? She says she spends it going from hotel to hotel while owning a house. Explain to me how that makes any sense. A woman receiving nearly $6,000 a month, who owns a home, who has vehicles, yet presents herself as a helpless victim with no resources. And even so, she keeps demanding more money. The $75,000 she claims she's owed, a share of the investments, a share of the house, the cars. She wants everything, but says she only wants what's fair. Meanwhile, her ex-husband is just waiting for this case to be over. He's been dragged through a process that's gone on for months with no progress because she's unorganized, hasn't submitted evidence, and still hasn't secured legal representation, despite having the means to do so. Is this justice, or is it abuse of the system? We've reached the end of the video, but before we go, the questions are for you. Do you think someone receiving nearly $6,000 a month can still argue they need more help from the system? And what's your take on representing yourself in a case like this? Courage or mistake? If you enjoyed the video, make sure to give it a thumbs up, subscribe to the channel, and hit the notification bell. Your support means the world to us and motivates us to create more content. Stay tuned for the next exciting video from the wall.